Hello, dear fellow panelists and dear participants, and welcome to the DRBF Insight webinar series, Dispute Boards in the Sustainability Sector. This is the first session out of a series of 4 we proposed ourselves for 2022 on this topic. Today, we'll be looking together our colleagues from the World Forum for Offshore at why offshore wind projects are different in terms of disputes, the cost-benefit analysis of standing dispute boards, and the steps being taken by WFO and DRBF to reduce and resolve disputes. I am Georgiana Pekuch, a member of the DRBF Board of Directors Region 2, representing Europe, and I'm your host for today. For those of you new to DRBF, the Dispute Resolution Board Foundation was established in 1996 by the creators of the dispute board process with a mission to develop dispute avoidance and effective resolution for construction projects. Today, the association has almost 1,000 members in over 70 countries, as the dispute board process has expanded worldwide and is now used on a wide variety of projects and long-term contracts of many types and sizes. The DRBF develops best practices and offers training and educational resources for project owners, contractors, and DB practitioners, as well as partners with industry organizations to adapt the DB process for new sectors. It may be of interest to you to know that DRBF is publishing a dispute board manual, which is a guide to best practices and procedure. DRBF has also published a best practice guidelines for virtual dispute board proceedings. Our moderator today is Nick Rigby. He's a chartered engineer and fellow of the Energy Institute and has more than 35 years experience across the energy industry. He started energy management consultancy to provide contract management and expert witness services to energy companies who find themselves involved in disputes. Nick has experience of dispute resolution across multiple jurisdictions and project types, and his primary focus is on grid and offshore wind projects. Prior to starting Energy, Nick was head of contract management at Low Carbon Contracts and dispute director and head of strategy with the RWE Energy. He will be joined today by our guest speaker on behalf of World Forum for Offshore Wind, Tobias Voigt. Tobias was admitted to the bar in Germany more than 20 years ago, has been a competent lawyer who has accompanied complex engineering and construction projects worldwide in the areas of infrastructure, energy generation, mobility, and process engineering. Tobias heads the working group on international construction law of the German Lawyers Association and is the chairman of the Offshore Dispute Resolution Committee of the World Forum Offshore Wind. On behalf of DRBF, we have today Leo Gruters, past president of DRBF Region 2. Leo is a construction engineer and a dispute resolution expert with over 35 years of professional experience. He holds an MBA and is a fellow of the Chartered Institute of Arbitrators and a member of FIDIC President lists of approved adjudicators. He has been involved as an independent neutral expert in many large prestigious international engineering projects involving such wide-ranging sectors as roads, waters and sanitation, reticulation, railways, power generation and distribution, offshore, marine, renewable energies, and so on. He's a forensic analyst focused on the logical and fair resolution to contractual disputes. They will be joined today by 2 esteemed offshore industry professionals. Dr. Ralf Hangebroek, head of legal and contract management of Global Tech One Offshore Wind GmbH. Since his admittance to the bar, Ralf, in 2009, Ralf has worked for 2 renowned construction and offshore-related law firms and became in-house counsel and is now head of legal and contract management for Global Tech One Offshore Wind, the 80 turbines and 400 megawatts German North Sea wind farm commissioned in 2015. Ralf brings vast experience on offshore wind disputes and their roots in contracts and technical circumstances. He will be joined as well by Toby Edmonds, Chief Operating Officer at Maple Power Limited. Toby is an experienced offshore wind project director, projects for which he has had full P&L responsibility, reporting to several major external investors, including Galloper and Greenty Moore. He now manages Maple Power's European portfolio of development projects in France, Germany, and the United Kingdom. Toby has a strong record of a dispute avoidance based on early identification of issues, followed by early intervention so as to find solutions that meet the needs of the employer and contractor. Before handing over to Nick, I'd like to tell you that we will start with a few brief presentations, following which we'll ask you to address questions to the panelists. Please use the function of Q&A for your questions. If we go over the 1 hour time mark that we proposed, we could continue for another 20, 30 minutes, if just for you to be aware of. And I'm being told, I'm sorry, that our slides cannot be seen, even if I am on the presentation format on the screen. The problem is, I don't know why it's not showing on your screen on the presentation format. I'll try again. Can you see it now?
Yeah, perfectly.
Yeah.
Okay, thank you. Finally. I don't know why I was on full slide share. So Nicholas, if you please.
Good. Okay, if you'd like to move on to my first slide, please. So yeah, the good news that we'll start off with is that actually wind and to a lesser extent offshore wind is actually more successful than other infrastructure projects in terms of the mean cost escalation from this study that was done a few years ago, admittedly. It is that offshore wind comes in at typically about 10%, onshore even better at 1%, but that is significantly better than most other infrastructure projects and is only beaten by solar farms. Now we're going to use some of that data in a minute, but so I'll come back to that. But moving on to the next slide, one of the issues that offshore wind has to deal with, which we'll see on the slide with the pie charts, please, Georgiana, is that the structure for offshore wind projects is that it is multiple contract. So if we do a comparison of multiple contract with a single EPC, we'll just take for a typical, or not a typical, but set a 90-day loss of revenue due to the late completion of the project. In the case of a single EPC contractor, the lost revenue for a 1 gigawatt wind farm typically will be about £45 million. If we assume that the LDs have been set at a similar level to the lost revenue, then those two would basically, fairly closely cancel each other out. But if we look at this from the perspective of a multiple contract, typically an offshore wind farm will involve 5 major contractors, admittedly not all the same size as I've shown here, but that's just to make the maths easier. If we look at this situation where again there's a delay due to one of the contractors, the lost revenue will still be £45 million. But because the contract size is smaller, the LDs on that specific contractor will be a fifth of the size. So hence only 9 million will be recovered. At the same time, the other 4 contractors will potentially be delayed and may have charges, costs that they can put back to the project. I've assumed that's 20% of the LD, so that would be about £2 million to each of the other 4 contractors. So if we look at this situation now, we see the lost income, £45 million, some recovery from the one contractor who's caused the delay of 9 million, but a payment having to be made to the other contractors. So now, rather than a almost balanced impact, we see that 43 million is lost by the project due to the one delay by that contractor. So if we move on to the next slide, what I've done here is I've looked at the impact of dispute boards. Now, this is based upon a fairly detailed study done by the Florida Department of Transport. So we're not talking about wind farms here, we're talking about the impact of dispute boards in themselves. And what that found was that the impact of a dispute board was that the possibility of delay was significantly reduced. So their disputes with dispute boards and having a delay was only about 1.8%, which compares very favorably with a 19.2 on their projects without dispute boards. Cost overrun comes down from 18%, 18% to 12, so not as big a reduction, but still significant. What I've then done is taken the 90-day delay and looked at that in terms of the probability, a probabilistic delay, 1.8% with a dispute board, 19.2 without, and the same thing with the cost overrun coming from that very first slide of being 10% of the project, which I've then multiplied by the probability of it occurring. So arguably these figures actually are understated, but the message is, I hope, reasonably clear, which is that we see a significant reduction in the probabilistic cost of the delay, as we would have expected by going down by 1/10. And we also see some reduction in the cost benefit, probably bigger in financial terms. Net result is that even after we allow for the cost of the dispute board, so the blue line represents the cost of a dispute board, we see a difference of between with and without dispute boards of 17 million. I've estimated the cost for a typical 1 gigawatt 6-year offshore wind project would be about 1.5 million, but we can see that it's a 10-to-1 comparison. Anyway, I'd now like to hand over to my next colleague, and Leo is going to talk about some of the more practical aspects. So thank you, Leo.
Well, good morning, everybody, and thank you, Nick, for that opening or introduction into offshore wind farms and also the use of dispute boards. I've been asked to come here today and give insights from a practitioner point of view, being a DAB, being a dispute board member, being the dispute resolution guy on projects like this. So before I do that, let me first give you my view as to how I see that a DB's role in any project, for that matter, is defined. In principle, the DB's role is always to assist the parties in bringing a project to a desired contractual commercial outcome. Because the DB is there to help the parties in dealing with their day-to-day issues as they come up. And we'll talk about that a little bit more later today. So what does that mean in practice? That means minimizing, and as I've written here in my slide, on purpose, read avoiding costly disputes, because many people don't realize that dispute resolution is actually for a DB the wrong word. Dispute resolution means resolving disputes. That by definition already assumes there is a dispute. Whereas a DB, if he does his work properly, he will always try to make disputes not even occur. He will work with the parties to try and avoid them from happening. And I think it's that particular aspect of a DB's role that Nick was alluding to just now, when he pointed out the differences in cost escalations where a DB is present or where none is present. Because disputes are huge costs for projects that are normally not budgeted for. However, a DB's role can change a bit, because obviously not every issue as comes up in a project can be dealt with without it becoming a formal dispute. So if a dispute does arise, then that same DB role changes a bit. And for example, under the FIDIC forms of contract, the DB's role then is especially where the parties empower that DB to make a decision on that dispute, a decision that is binding on the parties, at first not final and binding, but binding on the parties. And I think our legal experts coming to word later can allude a bit to that aspect of binding and final and binding. But what it means is that the DB makes a decision and the parties are bound to give respect to that decision and implement it so that the project can go forward. So the dispute is not making the project stand still. It avoids delays from increasing and carrying on and by simply giving a decision and then just get on with the job. Okay, Jana, thank you. So DBs, if you appoint them on projects, what should you be looking for? What kind of people are these DB people, these dispute board members? Now, from experience, I can tell you that if I rock up somewhere with my two colleagues on a 3-panel DB, people always look at us. So from who are they and are they going to be nice to us? There's this immediate standoff, it seems. And a good DB will always try and deal with that standoff straight away. So the DB must always make sure that there is going to be mutual trust and harmonious relationships between the parties and that DB. Now, how do you do that? So a good DB has a certain form of social and communicative skills. But also, he should give the parties the feeling that he understands the technical demands of the projects that he's being involved in. And I think those 3 things are the most pertinent ones. There are a host of other things that the DB should adhere to, but these are the 3 most important ones from my point of view. And never, ever forget, the DB process is a team effort. If you want to avoid disputes, it has to be a team effort. So from a DB perspective then, if I want to do all that, what I just laid out, I've got certain tools that I can work with. And those tools, brought down to its most crude elementary categories, is first of all my own experience and knowledge. I'm allowed to use that. And secondly, I have documents that I need to stay within the boundaries of. And those documents are usually the contractual agreements between the parties and the law. So you'll see here's the link between the DB and the law, and as well as the terms of the contract. Those are basically the tools that I have to work with. Now, the DB on offshore projects has a couple of challenges that make it very remarkable and distinct in offshore environment. Currently, to my knowledge, there are no industry-specific contractual mechanisms providing for an effective dispute board process. Yes, there are standard forms of contract like FIDIC, but they are not specifically catering for the offshore industry. The offshore industry, introduces new additional stakeholders or influencers not catered for standard forms of contract. I'm thinking here about, for example, at a marine warranty surveyor. A marine warranty surveyor plays a very, very important role in offshore construction. Yet if you look at the standard forms of contract under FIDIC, for example, that particular person with that huge influence is nowhere to be found. And therefore, if the parties have a problem concerning this marine warranty decisions or whatever he has said, then that presents an obstacle for a DB to deal with effectively. We then need to go around it and seek workarounds. Also, the standard forms of contract, in my view, are not drafted specifically for heavily equipment-loaded projects. Offshore projects are equipment-loaded. You have all sorts of different vessels. You have got special purpose equipment. All of that is heavy capital investment is required to get those pieces of equipment mobilized to the site and put them to work effectively. That is not given its true importance under the standard forms of contract, in my view. Again, which leads in a dispute environment to workarounds that need to be found. In addition, when we are dealing with offshore projects, we have to deal with other laws than just the country law. I'm thinking about maritime law to deal with, which makes it even more complex again. Also, often extreme impact of unforeseen, unpredictable issues negatively affect the risk balance. Now, the risk balance is an important aspect of any contractual agreement between two parties, because it sets out who takes what risk and to what extent at the start of the project. Now, on an offshore environment, loads of things can happen that threaten that balance to go out of balance, with all the negative consequences that are attached to that. The most obvious ones on offshore are UXOs, unexploded ordnances, or the weather. Also, in the standard contractual terminology, for example, I'm going back to FIDIC because that's what I know best. The terminology in the FIDIC books is not always geared to deal with the offshore environment. A simple example is the definition of the word site. Now, we all know in a construction project, there's a site. That's what everybody expects. But what is the site offshore? Where is it? So all these things present problems for the DB that needs to be addressed. And FIDIC has already for a while now been thinking about drafting a book specifically for the offshore industry or for the renewables industry. Let's hope that some of these FIDIC people are watching today and draw some conclusions out of this whole event that may lead to the offshore industry getting its true cognizance of the problems they are facing at the moment. That's my part for today, and we'll see what questions come up. May I now give to Tobias?
Yeah, thanks, Leo. At least some people are watching, so maybe Georgiana also can pass the message. But that's basically what we really have to deal on a day-to-day basis, how to match either contractual side, but also the procedural side to those requirements. And I'm representing today here from Hamburg, the WFO, which is the World Forum Offshore Wind, professional association dealing with this industry, with the offshore wind industry. And I want to touch upon a little bit the procedural side, because we tackled the question who to assign to such a dispute when you are a concerned party in this. So maybe some quick words about the WFO and the committee, the Offshore Dispute Resolution Committee. The WFO is a professional organization currently consisting of about 80 members, company members for the organization dedicated to the offshore wind market. And one important goal and objective that we had set is to promote ADR mechanism in the industry. And when you see on next slide a quick glimpse on our membership, this is through the whole life cycle of a project, from developers, utilities to suppliers, and also service offering companies. And throughout all of them, there was the problem addressed to us on the next slide, that parties involved in offshore dispute resolution often lacking the possibility to assign experts with that knowledge that Leo just have described. So there are a lot of ADR experts on the market that can conduct a dispute in a proper way, but of course never have dealt with, for instance, a captain offshore cutting cable in stormy weather, causing a jointing procedure afterwards, costing 2 million, and losing construction window, forcing you for a campaign next year, the following year, yeah, with tremendous costs on this. And to decide dispute properly, you should know about such situations and in what framework decisions have been made there, for instance, under the contract. So that was addressed to us right through the whole membership, that they would like to have arbitration or adjudication familiar with the needs of offshore wind, in addition to the mature ADR knowledge. So, and then we took that as a topic and started to set up 2 years ago in the WFO a new structure. So we set up a committee, the Offshore Dispute Resolution Committee, that we see as a governing body to set rules and to also set up an expert listing as an offering to our membership, but also to the whole industry, to get advice or even assignment or a determination of experts that could run disputes from a first step technical view. So we are looking currently at kind of sole technical adjudicator procedures. And there will be also an operational entity, that's the secretariat, that will support later, if that thing matured, also disputes right away. So that's the formal structure. And on the next slide, you see that we have a committee gathering every 3 months. So it's open membership to our WFO members. And basically, we are currently putting up individual WFO rules for expert proceedings in dispute resolution. So that's the current task of the committee. Next slide, please, Georgia. And we will tackle those expert proceedings, adjudication, and mediation. And in far future, also arbitration, but for this, the organization has to mature over some years. That's clear to everybody, I think. The current goal, with next slide, and further on, is the ODRC expert list, Offshore Dispute Resolution Committee expert list. So we set up an evaluation scheme for offshore wind experts to apply for the WFO ODRC list to be enlisted as an ADR expert in the field of offshore wind. So I just had a call this morning with our managing director, Gunnar Herzog. So we currently have 21 experts evaluated on the list, mounting further on, of course, but we do a thorough evaluation. You see it here with skills covered already. And a lot of that, what you see here in the listing, you can allocate already to the topics that Leo just have mentioned. It's also spreading, we appreciate that, around the globe. And yeah, it's further increasing. Next slide, please. So the selection criteria is based on 3 columns. So there's the basic expertise, of course, in offshore wind, but also professional skills in terms of communication skills to run a dispute, but also in the 3rd column, the pure experience in ADR as such, how to manage a dispute according to rules set or even setting up on their own. And then we have a scheme that you can see here, how the committee evaluates each application. And yeah, so we are quite happy how this process is currently running. It's really appreciated by our membership, and we hope that that list will increase more and more to have that offering in that direction that Leo also had addressed. So that's what I wanted to show to you, a quick glimpse on this development from a procedural and association perspective. Thank you very much. And I hand over to Ralph, representing offshore wind farm concerned with those problems, right?
Thank you very much, Tobias. So let's move on to my slides then. I would like to add some lessons learned from a practical point of view and also from an in-house counsel perspective, which is also, I think, quite interesting also for the further developments. First of all, I would like to mention one thing, that dispute planning in advance is important. It is true that nobody plans to fail, but unfortunately, many fail to plan here. Hence, already during contractual negotiations, provisions for a DB should play an important role. From my perspective, standing DBs are beneficial despite the costs, at least for the bigger project packages like wind energy converters. The DRB members should be identified and the DRB should be in place already at the date of contract signing. Also, according to my experience, there is still a lack of duly qualified and experienced adjudicators in the offshore wind industry at the moment. DBs should have 3 members with interdisciplinary background, engineers and lawyers, and DB members must have the motivation to make decisions within short time periods. It's not the right job for doubters. The experiences. According to my experience, disputes in the offshore wind projects are quite complex, maybe more complex than disputes in other sectors. The multi-contracting approach and interfaces make offshore projects complex and exposed to disputes. Furthermore, claims tend to have a high volume, as for example, the daily costs for a jack-up vessel put to standstill are enormous. Disputes should be referred to a DB as early as possible. Dispute resolution by DBs during, not after, project execution is a challenge, but provides much better results. As many freelancers are working in the offshore wind industry and are gone after the project is built to the next project, you have a huge problem to find witnesses with suitable knowledge when entering into lawsuits only many years after. Oral hearings are generally necessary in the proceedings in order to clarify questions of the DB. But the DB should have as much flexibility as possible for the process. For example, witness hearings are important, but can be done during the hearing in an informal way. The parties always want short time periods for decisions of a DB. But depending on the dispute, this is not always realistic. Deadlines should be ambitious, but should not lead to less persuasive decisions. The acceptance of the DRB decision itself by the parties is important. Therefore, for example, dissenting opinions should be avoided. Decisions of a DB are often used to resume negotiations between the parties and can be a real chance for subsequent amicable solutions. In summary, the experiences with standing DRBs are good, and it's worth to invest both time and money in the dispute resolution process at an early stage in order to get out better results at the end. You need to have a custom fit and detailed dispute resolution mechanism in your contracts. Otherwise, you will regret it later. Thanks for your attention. And I hand over to Toby.
Thanks, Ralph. So I won't be presenting any slides today. I'll just, conscious of time, just give a few comments from my experience as a project director, having faced a number of claims. I'd make 1 or 2 observations. The first is that the main objective, of course, is to get the wind farm built. And really the mechanism and the dispute board is really geared to make that happen as successfully as possible. And I think, you know, some of the things that Leo said are really important around preventing disputes from occurring in the first place through communication, and what Ralph said around planning being so important at the pre-contract stage to actually have a plan in place. I think as a wider industry, I was involved very early on with some of the first projects in the UK, and the supply chain and the developers were very inexperienced, and that picture has changed significantly. So there's a lot more experience in developers and contractors. However, the game is getting a lot harder. Unfortunately, we've built all the nice, easy sites in 20 meters of water on a nice sandy bank. And now we're in deeper water with more complex ground conditions. I think that is, I would say, the #1 area for the future for dispute resolution. So having a section in the contract purely on dispute resolution mechanisms for ground risk is probably sensible given where the industry is headed today. But that's compounded, of course, by the reduction in the levelized cost of energy, meaning that there's simply much tighter margins, much lower prices being paid, whilst the risk is increasing. So I think, you know, from my experience, it's really, really important to get the communication going between the parties. And I think the dispute board is an excellent way of doing that in order to accelerate the job. And I think that, you know, the other thing that Nick talked about, the potential cost saving of having a dispute board. But I would say the other thing that happens through resolving a dispute is then you get alignment back with your contractor on the project, and the completion of the project actually accelerates. In the projects I've been involved in, where we've been able to quickly do a deal to resolve an issue, dispute, or a claim whilst the project is still in flight, has had a hugely catalyzing effect on the completion of the remainder of the project, because the contractor then is able to spend money and make commitments to deliver the scope, and isn't worried about protecting their position in a claim or dispute management process. So I think there's huge value financially, but also in the overall objective of delivering the project to come for dispute management. I do think that as a developer, I can see the sense in the dispute board. I think, you know, I'd be interested in a more contractor perspective, because it does feel like a loss of control if you make the dispute board a binding decision-making group, and they may wish to retain that control ultimately to protect their commercial position. But I think it's a really positive initiative and something that's geared towards improving communication and better delivering projects. Thanks, Nick.
Thank you, everybody. We'll start the Q&A session now. We have quite a bit of questions piling up. So I'll start with Alfonso Pelos's question. Which percentage of offshore wind farms is contracted under a design and build, FIDIC Yellow or similar, and which one under a turnkey, FIDIC Silver or similar contract? Thank you. Alfonso from Rome. I think Tobias.
Should I give it a try? Yeah. So
Please.
In offshore wind, you often have a supplier market. So you have a few choices in your procurement procedure. So people reading FIDIC Silver tender often just being scared away, right? To knowing the risk profile that's transferred there to them. So the vast majority of the projects run on FIDIC Yellow, modified, adapted, but still multi-contracting approach with individual EPCI lots in this, 5 lots in general, for instance. So you run there with multi-general contractors, so to say, with on FIDIC Yellow. So that is, as a baseline or borderline, is the general distribution, I would say. See a lot of nodding with my colleagues.
Well, if Toby or Ralph or Leo would like to add something, or Nick, please feel free at any time.
I would agree. FIDIC Yellow Book is typically where the reference point is. It's heavily amended and edited, but that's the reference point.
First, you would have the logic contracts, oil and gas. The logic, for instance, distinguish between soil seabed waterline stuff completely unknown to FIDIC Yellow, of course, because rather onshore contract marine warranties were not known, as Leo said. So this all has to be implemented, and there might have been other contracts a better choice even in the beginning, but my sensing also was always that the industry tried to set up something new because they were new themselves and didn't want to rely on oil and gas contracts, for instance.
My first wind park project was in the Baltic Sea, and it was actually done under a FIDIC Red Book.
Okay.
A Red Book, but, and there's a big caveat here, the whole purpose of the Red Book, of course, is that the employer designs everything. And in this particular project, the Red Book was chosen, but the entire design was then back outsourced to the contractor. So they tried to create a Yellow Book from the Red Book, and it caused disaster. I'm not sure what went into the heads of these people that actually developed the project. If they'd chosen a Red Book, they should have known there's also such a thing as a Yellow Book. They didn't need to actually redraft it. Currently, my jobs on offshore are predominantly Yellow Books, as you said. I would guess that Silver Books are out of the question for contractors. Just seeing the highly risky nature of where we are in the middle of the waters.
Yeah, I saw some HVDC converters being addressed on that basis, but then of course also heavily negotiated and modified in the tendering procedure then, of course. And you might get 250 deviations from the bidder then to negotiate, right?
Well, what also should not be forgotten is the moment you have a proven over many years proven standard form of contract like FIDIC, if you are going to change it, you better know what you're doing.
Mm-hmm.
This particular form of contract, FIDIC, is proven in a sense that it actually reduces disputes. But if you start playing with it, if you start giving it changes and you're not too sure about what you're doing, you're creating an even bigger problem.
I'll go to the next question, and I think it's for Tobias as well to start with. What activity, if any, does WFO have with onshore wind projects? And if none, is there any organization of similar nature for land-based wind projects?
Yeah, so we are fully concentrated on offshore wind. So our organization is not involved in onshore wind, but many members are, of course, because they have versatile portfolios addressing renewable energy as such in general. And there are other professional organizations dealing with that, many, but I don't know of any that tackles this dispute element as we do. But I think it's also more urgent in our area because of that complexity and peculiarities that were addressed already by the colleagues. And yeah, and we wouldn't even have the ability also time-wise to cater for that. So we have the full offshore wind focus.
Thank you. Another question for you though. Yes, Nicholas, sorry.
Yeah, sorry, just to say that I think the nearest is the Global Wind Energy Council, who cover worldwide and cover both onshore and offshore wind. But they're much more focused on political lobbying and let's say the development part end of the spectrum. So as Tobias says, they don't have any activity in this area. And as we've set out, onshore wind farms, based upon the data from the study that was done, it's a tenth of the problem. So and also you're much more likely to get a single EPC contract for the entire project. So offshore is A is the big growth area, and B is the area that needs the attention most. So yeah, thank you.
Thank you, Nicholas. So Tobias, what has been WFO experience with GB use of virtual meetings and proceedings under the WFO system?
So we have, I think the most interesting was what I read recently from a colleague in a restaurant next to German Autobahn, going virtual. It's all possible. Now, of course, you need a certain discipline to get through online meetings, but we see it in our law office also now with, of course, with the general courts, that you sit somewhere and dial into proceedings, but it really needs discipline to get through that, and this should be aligned before, a little bit more than you could intervene in a face-to-face meeting than what is possible in an online meeting there to still do some housekeeping when it's already running. I sense that always that's a little bit more complicated, and you need stricter rules there which is then another task for the adjudicators to follow and to set up front to run it.
I would like to ask Leo to add on to this, given that DRBF, through Leo's guidance, put together a virtual dispute board proceedings guidelines for the DRBF professionals to use. Leo, if you have something to add on this topic, your experience on it.
Thank you for that topic. The last 2 years, of course, have proven to be very significant in the development of virtual meetings, whether we like it or not. Corona meant we can't travel, and we were forced to adapt to this situation. In the beginning of the Corona pandemic, we as adjudicators thought, well, okay, that's going to be it then. No more projects. Projects will have to come to a standstill, but that never happened. So we needed to adapt, and we came up with virtual meetings. And may not be for the example anecdote I'm going to give you now is not exactly the wind industry, but a roads project in Africa. I was sitting in Germany, proverbially on the Raststätten on the Autobahn, as you alluded to, and we had guys in Africa with a drone, and the DB is one sitting in Germany and two in the UK. We were having video recordings, or not recordings, but video footage shown to us of things that we wanted to see by somebody in Africa flying with a drone over the site. So we became very versatile in doing these things online. And what is the next step in this was that the employers, project owners, and also the contractors start to realize that when we do this virtually, the project still went ahead. We still got things resolved, but they didn't have to pay the travel cost and time for the DB members. It became a cheaper version of having meetings. One of my current offshore projects, also again in the Baltic, is where we have one in-person meeting and the next one, regularly one, is in virtual meeting. So we've combined the two. And this is, I think, the trend that you see happening more and more often these days.
Thank you, Leo. This is a question from Ben Goss for all our panelists. So please, two questions, sorry, actually. So first one, generally speaking, in the panel's experience, are there more or less disputes in the offshore wind sector as compared with the onshore construction? And the second question, the panel identified that expensive equipment and vessels are involved in the offshore wind farm developments, which are not catered to in standard FIDIC contracts. Nevertheless, the maritime industry has developed standard contracts for vessel chartering. So, to what extent does the panel think that the offshore wind sector must reinvent the wheel versus embracing solutions developed over many years by the maritime sector already? BINCO suite of contracts, for example. So who would like to start first?
I'm quite happy to say a few words on the second part, but
okay, please proceed, Toby.
Maybe I'll do that. Maybe someone else can answer the first one. I think that the important point with vessels in particular in the offshore industries is that the risk should sit with those best placed to manage it. And so what's tending to happen in the industry, which I think is very positive, is that the installers in particular are buying their own vessels and integrating that into their product offering to the offshore wind market. Because previously, when we had, say, separate BIMCO charters for vessels and contracts with foundation suppliers and installers, we got into a terrible mess where the foundations weren't ready, but the vessel turned up, and vice versa. So I think it's much better that they manage that risk, and it's even better when they own their own vessels, because they're able to optimize the schedule and don't have this sort of a very difficult and complex task of trying to juggle jobs and commitments with different contracts. So I think that as a developer, we'd like to see less contracts with vessels. We'd rather see it with EPCI contractors. And I would say that, you know, because of the integration of the tools and equipment and the vessel, it's not like buying cargo shipping. You're buying an installation spread. That it's probably more appropriate to have an installation style contract than a vessel charter.
Yeah, basically we ended up then with a BIMCO contract, for instance, knock for knock principle and liabilities, and a monopile foundation supplier. Never heard of that before, even struggling to understand FIDIC as such as a system, because it was also all new to them, maybe if they hadn't been into that international market before. And those are then kind of clashing on interfaces, because we were sitting on, or still sit on, that multi-contracting approach, because we didn't find somebody for the 1 or 2 billion euros to provide as a full EPCI one-stop shop contract. So, and that's exactly what Toby said. So that was right from the beginning a problem, to combine those established mechanisms where the vessel owner also told them, for instance, if now the monopile supplier tries to integrate that into his product, as Toby said, he sits with that problem, because the vessel owner will still tell him, you can have my vessel on BIMCO terms, and if not, just go to somebody else, right? So then it is put further down the supply chain, but it still sits there as a problem.
Anyone wants to add up on the second question, or shall we move to the first question? I could reread the first question if you want.
It's okay, Georgiana. I mean, I think the first question is partly answered by, you know, the research that I showed in my slide. It's on the assumption the question is about onshore wind projects versus offshore wind projects. And certainly my experience is that that sort of ratio of something like 10 to 1 in terms of, you know, percentage overrun is right for so offshore is by far the bigger problem. If the question is directed at, are there issues with the onshore part of an offshore wind project? Well, yes, that certainly does happen. And I guess the big driver there is that the onshore, which is mainly the onshore substation, and secondly, the cable coming ashore, is one of the interface points with a regulatory body. So in the UK, at that point, you are interfacing with a regulated party in terms of the transmission company. Other jurisdictions, the interface is elsewhere. And that can be a cause of problems, because you can write whatever you like in the contract, but if the regulatory body says, oh no, it's got to be done this way, then there is a potential issue there. And certainly in my experience, that is one of the problems that's, you know, I mean, obviously all generation projects are going to have that sort of issue, but offshore wind has it in particular, I guess partly because of the fact that you're generating the wind offshore. So by the time it gets onshore, it's in a different state in terms of reactive power, etc. So there are certainly challenges as part of the onshore part of the project.
Thank you, Nicholas. There is another question for Tobias, but then I would like to ask all of you to comment and give your own perspective on that. So the question goes, does WFO suggest a single DB to deal with all aspects of a project, from design through manufacture and finally construction and operation? If so, for how long is the DB expected to serve? If not, how is this sequence of, and the question is unfinished, but I presume it's looking at. So Tobias,
maybe I'll give it a
please, you're
start.
looking at a single DB or 3-member or 5-member or multiple?
I think everybody who was involved in a heavy dispute with a large extent and would love to see that this was installed right from the beginning, covering the whole thing with no break of data in between, no knowledge lacking and transfer necessary. Well, of course, it comes with a cost, and you still have to find people, and that's what I think what the question suggests, that are then ready to deal with those issues that are coming up, which would be a very versatile profile for a whole wind farm when we would imagine, what could happen there. On the other hand, to have an overall structure and then additional experts assigned to it on need basis, that's of course also appealing, which is what you would come across a ordinary court setup, for instance, anyway. So that's also something to consider. We are not final in that opinion that we have there, though. So that's really a deep discussion currently in our committee, and we will reflect it in the rules to come, of course. But the practical view is, as I said, would be good if they would have been there right from the beginning. But then you have already a very dedicated view in a dispute happening, what was required, which of course you don't have in the beginning to set it all up.
Thank you. And just a little bit of careful, the question is asking also about operation, and now I'm tempted here to make a parallel with the Gold Book. Leo, what do you think about what type of dispute board should we have in an offshore project?
I saw the word operation as well, which leads me to think about the Gold Book, yes, or any sort of concession type of contract. I think offshore wind farms concession type of contracts, I'm not sure whether that's are there any at the moment. I think the other panel members can give a much more detailed answer on that. As far as the time that a single DRB is going to be involved in the project, from design through to manufacture and finally construction and operation, I would hesitate on the operational bit for the moment, being it offshore, but I would certainly go through from design all the way through to construction and defects notification period after that. Whether you have one single DRB, 3 DRBs, or a multitude of DB members, that depends on the size of the project. We have to keep in mind that we should not overload the project with additional expenses just because you want to have some DBs there. That's not what this is all about. You need to have the number of DBs right for the type of project that you are aiming for. Very, very large projects could do with a pool of DRBs, let's say 5 or 10 of them. And from that pool of 10, you choose for every dispute that arises, you choose a chair who then picks 2 others from that pool of 10 to form a trio. These are proven methodologies in other onshore projects that I've been involved in, and I would suggest that it could also work offshore.
Especially since there are strict specialties that you might need experts for. Ralph, what do you think about this?
Yeah, I also fully agree. It's according to my experience, as long as you have a multi-contracting approach and you have a lot of interfaces, it's not possible to have one DAB for the whole project. You need to have certain specialists, for example, for soil, for foundations, for wind energy converters. You need to have specialized engineers for that, and this is why I think it's simply not possible to have one DAB from the beginning, being there as a standing DAB, serving all the way from through the whole project until operation. It's simply not possible. So you need to have specialists in the DBs, and that's why I think it's in the normal projects in Germany where you have, for example, 5 main contracts with a multi-contracting approach. It is worth to have DABs for each contract as they are big, and The DB members simply cannot serve for all the contracts. They need to have they need to concentrate on a single contract. This is my experience.
Thank you, Ralph. Toby?
I agree. It's a lot to ask given the complexity and the difference of the contracts to ask one party to do it. Clearly, having the continuity is really important. That's really helpful. So maybe there's a sort of more of an oversight role, but I think specialists are required for different packages.
Thank you. A question from Nils Kirchhoff. Are there golden rules existing setting up a FIDIC-based contract in the offshore wind industry? What to consider, whether MWS, and how the definitions should like? Who would like to start on that?
I
would ask Leo, given his experience in FIDIC contract drafting in particular.
Yeah. As I said before, FIDIC to me is a standard form of contract that has been put through the test time and time and again over many years. However, having said that, the offshore industry is in dire need of a specific form of FIDIC contract, I believe. And it's not there at the moment. So you're not going to get away from the fact that if you go offshore and you want to use FIDIC, you will have to choose one at the moment and start making adaptations with all the risks associated with it. Or you draft a bespoke contract and start from scratch. This is the problems that the lawyers are faced with that are mandated with getting these contracts right for offshore projects. So I'm not sure about the golden rules to set up a FIDIC-based contract. To me, if you want to use a FIDIC, try not to change it too much, because every change you introduce, you are creating an additional potential problem.
Sure. Ralph, your experience on adapting contracts, bespoke contracts for the industry? You would prefer a new form, or you would prefer to work on an existing form, just adapting it?
At least this is what happened in the past years, that you were adapting FIDIC contracts. I would love to see a FIDIC offshore construction contract, but it's always the same, that there have to be negotiations for single provisions to be amended from time to time. It's not possible, or it's not possible to have a standard form of offshore construction contract being unamended in negotiations. And there are always certain provisions which have to be negotiated for a single project. So it's difficult to say what are the golden rules for that. But of course, you need to have provisions for the MWS. Weather is quite important. Soil is important. But that all has to be negotiated in each single case, I would say.
I think the appealing thing in a standard is that when a supplier looks at tenders available and where to assign its capacity, having a standard and seeing deviations from that and judging that quickly, because 13 is variation, you quickly look it up. The appealing thing is that you can judge quicker the risk profile, which is also beneficial for transaction time, finally, in negotiation. And if there, as Niels has addressed, for instance, if the NWS is there in standard, and you can quickly judge, is it in the review time of 4.2 for contractors' documents or not in the cycle, or whom the person is assigned to in terms of liabilities and responsibilities. And that's a benefit for transaction time, in my view. So, and also for suppliers to decide what would be most promising tender procedure for us to concentrate on, for instance, an auction regime with competing utilities or developers.
Two golden rules I would suggest is, first of all, you are going to have to change the contract, or you're going to have to draft something from scratch. That introduces problems, as has been flagged. Very constructive approach to reducing those problems is, as you get close to the point of signing the contract, get somebody who's not been dealing with that contract up to date, i.e. bring somebody in from outside to review the contract and make sure that there aren't conflicts between individual clauses, because that is so easy to happen, in that you change and you fix one clause, but actually there's another clause somewhere else that is then going to be a conflict with. And the second rule is, most people who are building these projects tend to go on and build the next one, and the most of the learning is carried across. But because of the problem, again, Leo flagged it, many independent contractors, it's worthwhile being disciplined in terms of putting a sort of lesson learned and doing it clause by clause, so that next time a colleague is dealing with a similar clause, they can look back and see what the problems were on earlier contracts. So those are my only two golden rules that I would add in, which is A, get a review done before signing, and secondly, keep a knowledge base issue by issue of your learnings, and including obviously near misses as well, because the major problems you will remember and everybody knows about. The near misses you tend not to pass down from one project to another, and it's vital and useful learning.
And perhaps that's the to be taken on board by WFO contracts committee when they're updating their drafts or proposed clauses. Or I think they should be the treasury of the offshore wind contracts, Tobias.
That's a treasure.
It's a treasury already. Okay. A question from Svetlana Borisova. One specific issue which has repeatedly causes disputes in the offshore wind project is a failure of their foundations, sometimes originating from miscalculation in the strength of the turbines and the remedial costs associated with this work. If DAAB is tasked to determine whether the contractor has exercised a reasonable skill and care in constructing them and whether they were erected to be fit for purpose. As FIDIC is not very specific in those clauses, it will be interesting to hear from what contractual test clauses would you apply or use to determine if the contractor is liable for the remedial costs or not. Are there any particular conditions what the employer should include to cater for that?
It's that great question about did I get what I ordered or did I get what I need?
So who would like to go first on that one?
As a developer, we always want what we ordered, right? So it's
okay.
It's the first one, not the second, but sometimes we're left with the second. I think probably Nick may want to comment on this one.
Yeah, I think actually this is where the real strength of a dispute board can come in, because what happens is that when the contract is signed, what the project needs and what the project asks for should be the same. I mean, if you don't have the same when you sign the contract, then you're really going to have problems. But usually when you sign the contract, the two are the same. As things develop, i.e., the regulations change, the ground conditions are found to be different than what you expected. You've got all these contractors who've been working independently who you need to be working together, and they may find that they cannot change the tower so that it works with the turbines. So you've got this problem, and you've got to bring the two back together. And if you look at it from a pure legal perspective, well, you either say one party pays or the other party pays, and that's not really the best way of managing it. And that's why I think a dispute board can add a lot of value, because they can say, look, you've both got to recognize that the environment has changed, and what is needed and what is contracted needs to come back together, and both parties have got to make some movement back together. So contractually, I don't think you can't cover every eventuality, but with a dispute board, you can bring the two back together sooner rather than later. I mean, we look at, one of the instances of foundation issues, which occurred several years ago, and it's still only now has been resolved. So if you can bring those things together early enough, then it can be done in a much more, let's say, cost-effective way. And as I say, I think that's one of the big arguments of dispute board.
May I just add to that, Georgiana? Thank you, Nick. You mentioned before that you would ideally like somebody to have a look at the draft contract right after that the drafting is finished and before it gets executed. I would see the dispute board as an extension of that. A good trained dispute board who practices dispute avoidance wherever it can will actually look at those contractual documents with exactly that view, trying to find future possible problems and bring them to the parties' attention before they escalate into insurmountable issues.
Thank you.
I think, so as Nick said, you can't describe everything on the contract. And if you're sitting with such a complex structure there, like offshore wind, of course, you tend to go to draft fit for purpose clause into it. And that's what you find across the board, I would say, in those projects and lots, with the lot supplier, the general contractor, of course, facing reasonable skill and care, tried to be included in his supply chain, of course, where he puts everything together, because certain standard equipment suppliers would say, we will. If I would sign a fit for purpose contract, I would lose my sales job here in the company. So that's a spread that the suppliers have to deal with. And I still loving the E.ON Renewables versus Højgaard, MT Højgaard decision on foundations. So I always take that as example, because every participant could read it, Google it, as it was a public decision in the UK by ordinary court. And finally, it was that the foundations didn't provide for the 20 years lifetime assured to them and requested in the contract, but purely to the fact that the standard applicable for designing a foundation at that time had been faulty. There was a defect in the formula included in that standard. So basically, the supplier did everything what you normally would have expected, reasonable skill and care. You apply a standard. Of course, you don't recalculate the standard or even applying a math guide to do that for you. You just do it. But the court said, okay, fit for purpose, that's overruling. So the 20 years more general requirement supported by fit for purpose, that's overruling that defective standard that you applied. So with that little term as addressed here by Svetlana, that might be decisive for your whole project then. But I'm not sure if a DRB would have decided exactly the same like this public court, and that's exactly what Nick addressed. I think there's a little bit more room to maneuver with the parties on such a question. And I'm not sure if the outcome would have been the same.
Okay. Ralph, would you like to add to it, or shall we move further?
I think I agree to all the points, but let's tackle the next question, I would say.
Okay.
We're going too much into detail.
Yes, it's an interesting question now, coming from a very sensitive one nowadays. Jeremy Nicholson is asking, as risk of offshore wind project increase, are insurers likely to have more involvement in project and disputes? Who would like to go with this?
Unfortunately, yes. So you could
That's
read,
a simple question, yes.
you could read in the press, I think it was last year, that, for instance, Ørsted made contingencies of more than 450 million euros for cable defects, cable claims in their portfolio. That's all operational phase. You would address it to the insurance, of course, which came to a point that when I was beginning the industry, 2008, you had the normal deductibles of, I don't know, 250K in a cable contract, 500K maybe. And now it's about 2.5 million deductible that you have to accept if you want to have insurance for a cable lot. And that means a lot, no? Because they might be defective themselves, people throwing anchors on it, whatever happens to this, and they're problematic as such, also from design, terminations, everything. It's a complicated thing. People think cable is very simple stuff. It isn't. So, and that's always addressing insurance. I saw Barbara on the call. She might have additional view on this, but that's really bringing more and more insurance into the topic. And then you might have sailed out with one vessel, remedying defect and a damage at the same time, and the loss adjuster by the being assigned by the insurer might say, oh, but you have to distinguish with that. So you can't now put forward this as a total compensation request towards the insurance because damage is not insured under your contract, but you say it out with a single vessel costing you 80K per day, what to do now. So that's special knowledge also required to deal with that insurance structures that are terra incognita for many people. So where you just say, 17 insurance, okay, let's tick it off. Expert talked about it, let's sign the contract, right?
Well, Leo, here, we always say that dispute boards are an insurance for the project. Do you think that the insurers would be likely to be more open to insure projects that are using dispute boards?
I don't have any real-time experience on that in the offshore industry. But what I have noticed is in other construction projects of higher value, where car insurers start having an interest in whether DRBs are present or not. I think insurance companies through the board have started to realize that what Nick alluded to right at the beginning, that when DBs are involved, the project risks are actually minimized, getting less. The contractual project risks are getting less. So yes, insurance companies are on the onshore side are taking interest. Offshore, I can't really say with any practical data.
Thank you. Well, there is from John Papworth, bearing in mind the role of the DAAB to avoid disputes, one of my early remarks to the parties and the engineer is, I give you a challenge. Let's see if we can finish this project without any disputes being referred to the DAAB. I think it's a challenge for the dispute boards as well, isn't it, Leo?
I think what John is saying here is, and I've known John for many, many years, and he's a very good colleague of mine. And it reminds me of a FIDIC conference in Bucharest many, many years ago, where John and I were there. And in one of the speaker sessions, I actually mentioned it. And I said, the best, most effective dispute board is the one that never gets referred to. And this explains in detail how important it is for a good DAB to actually practice dispute avoidance. Because if you do the dispute avoidance bit properly, the referrals you're going to get are minimized, absolutely minimized. And the best is if you don't get anyone at all.
Do you agree with that, Tobias? You're on mute.
I had myself some water and muted for that time, sorry. I think many of the offshore wind projects in the past managed to do so, actually. So that's also what Toby mentioned. So it was a maturing industry. You come across every second day with the same supplier for the same lot. Vessels booked out over years. You have to get along somehow. But also the money was still there. So if you get 150 euros for your megawatt hour still on the early German projects, for instance, there is room to maneuver. If you have a zero subsidy project with fully merchant risk, like Hollandse Kust, for instance, and a vessel rams into your foundation and your jacket structure, of course, there's not much to solve there amicably, so to say. And we are moving into deep waters, as Toby said, and just recent announcements, again in the press, you could see Saipura terminating a full installation contract this week in Taiwan. Saipan calling off, I don't know, 800 million from their earnings as a loss due to Scottish wind farm. We all know which one this is. So problems really getting bigger, also with suppliers coming from other industries totally underestimating what it needs to do those jobs, basically. And that will increase disputes all across the board. Whatever your approach is to it. So of course, this indication is completely true, but the avoidance is one part, but offshore wind, I think the managing to it, that becomes more emphasized in the future.
Thank you, Tobias. Sorry. And a last question from Bill Barton. Does the panel consider that there are sufficient number of experienced contractors and consultants to meet the increasing demand for offshore? Thus, experience brings knowledge and a closer working relationship. But every time you have a new contractor, you start again. So are we having sufficient number of experienced contractors and consultants? Toby?
I think it's easy to say the answer to that question is no. I mean, in an industry with a growth trajectory like offshore wind, clearly there aren't enough good people out there. I mean, with the recent awards in ScotWind of another 25 gigawatts in projects, all now trying to fill their project team with competent and capable people, it's an impossible task. So I think it will continue to be a challenge. It probably means that we will repeat some of the mistakes made in the past as we lose or miss some of that experience. So what was referred to earlier about by Nick about lessons learned from projects in industry forums like the WFO, for example, is super important, because that's a way of trying to preserve that knowledge and experience and spread it across the industry. As you know, good, competent people come in from other industries and with great qualifications, but nothing trumps experience. So, you know, we need to make sure we're getting the best out of that experience as an industry.
Thank you, Toby. Rolf, you want to add to it?
Oh, I also said it in my statement. There is a lack of suitable people, not the lawyers, the engineers. You need to have engineers which have experience both in the industry, but also in dispute avoidance and dispute adjudication. And there are only a few. It's and for some there are conflict of interests and so on. So it's not a huge market that you have. You have to really be careful to pick the right people also. And there are some lists for adjudicators and all that, but it's a very narrow market, I would say.
So we should look into, sorry to interrupt you.
No,
we should look into training more engineers into dispute resolution
sure.
methods and how they could proceed. And perhaps that's a job that we could do together. Well, I thought there's the last one, but there are two more. And Franz I'll say Franz from Indonesia. DAAB is a powerful for the avoidance function. How about ad hoc DB? Is there any possibility to include the avoidance function to ad hoc DB?
You want me to have a go at that?
Yes, please.
The obvious answer that everyone would expect is no, simply because of the definition of an ad hoc DAB. But I would like to put that in a bit more perspective, if I may. Ad hoc DABs by definition, only get formed once a dispute is formed. So once the dispute is there, what else is there to avoid, right? It's there. That's what you have been called in for. However, as a DRB, I tend to look for distinctions in projects and when I get called in. Usually you have a red book or a pink book contract where the DB should have been appointed as a standing board way at the beginning, but it never happens. So once the parties get into a fight, they then decide, oh, but we now need the DRB because otherwise the road to arbitration is blocked and blah, 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 blah. So the DRB has to come in and then sort of ad hoc DRB is formed. In that particular situation, there's absolutely no need to do dispute avoidance because the parties have called you in because they have tried everything before you to get a resolution or amicable settlement and it didn't work. So I would still ask them if there's room for that, but I would expect the answer to be no. Compare that to a yellow book situation where the ad hoc DRB, the 1999 yellow book I'm talking about, not the 2017 version, but the 1999 version calls for ad hoc DRBs when a dispute arises. Now, this may be a dispute that is not necessarily already entrenched by the parties. So I always have a go to parties and see if they are having an appetite for getting it resolved with less cost if I switch from adjudicator to a mediator mode. So in that aspect, even at an ad hoc situation, I can do dispute avoidance, but it has to be carefully thought through by the DB in what situation you can and where you cannot.
Thank you, Leo. A last comment from Malith Mendes. I think we can adapt a contract in similar fashion to Emerald Book with a baseline hydraulic and climatic conditions defined. I have a hydraulics engineer background. Thank you, Malith, for this.
I love that comment, because when you just take unforeseeable physical condition clause, so in the yellow book it says the obstructions the contractor encounters, something like that, including subsurface and hydrologic conditions, but excluding climatic conditions. And then just reflect that on your offshore seabed, wave, whatever situation, groundwater. It's completely not, it's just not fitting at all. Even me as a lawyer can understand that. And this is something definitely to be worked on if you would address offshore contract. But even logic doesn't distinguish that, for instance.
Thank you. I would like each of you to give a conclusion, a final statement, and I'll ask Nick to start with.
Well, I'm going to come back to this standing versus ad hoc boards and say that a football manager wouldn't operate with his goalkeeper sitting on the bench, which I would see as being the equivalent of an ad hoc board. So yeah, I hopefully that little amusing way of describing it will reinforce the message.
Thank you, Nick. Leo?
Well, first of all, Georgiana, my fellow panel members, thank you very much for organizing all this, and I'm very honored to have been part of this. I think it was a very fruitful discussion. I'm pleased to see that amongst the other panel members, for example, Ralph in his presentation, and also Nick, have alluded to the fact that DBs are necessary, standing boards are necessary, they do a good job, they actually save money. And this is something that we as DB members have been fighting for as a recognition for the last 20, 30 years. So finally, we're getting somewhere. That's very good to see.
Thank you. Toby?
Yeah, I mean, just to reiterate some of the things that were said, proactive management of issues that may become disputes is key to getting the project built, which at the end of the day is the whole point. So I think this is a really positive approach to trying to get the project built.
Thank you, Toby. Ralph?
Yeah, first of all, also thank you very much for giving the opportunity to report on some lessons learned. I like Nick's statement of the goalkeeper picture. It's a good, very good picture. And yeah, I think the point is we are all persuaded that standing DBs are sensible, but we have to persuade other people. We have to persuade managing directors. We have to persuade financing banks. Everyone who has doubts. This is a challenge still. So this is what we always have to keep in mind. So I think it was also very fruitful discussions, giving a lot of arguments for standing DABs. So it's yeah, thank you very much.
Thank you, Ralph. So again, another topic that we could work together on. Tobias?
Yeah, also thank you to everyone, also my fellow members for that discussion. And I really, so with the remark of Ralph, I remember one client, head of legal, addressed to me like, well, it's rather unfair. The supplier prepared 12 months statement of claim, addressed it to ad hoc DAB, and we have 30 days to answer it. But that's not the real problem. The real problem is, what did you do in claims management before? How could that surprise you? And why you're not working with a standing one? Because that is the different result. But exactly as Ralph said, this particular client in his standard forms erased ADR mechanism due to this. But it's a question of, and now it's even worse, of course, and it's a prep question, but also assigning the right people. And that is what we want to work as WFO for, together with DRBF.
Thank you, Tobias. And thank you all panelists. Thank you, WFO, for joining us today. Thank you, Ralph. Thank you, Toby. And I would like to invite you all to our second session on dispute boards in sustainability industry on 14th of April. Thank you very much. Goodbye.
Thank you. Bye-bye.